Inheritance law in their country is clear. Children must be paid market value before a parent can sell shared property. So when my Aunt Karen handed my grandmother a pre-filled deed and accepted a price of $3,000 for a cabin worth over $200,000, it wasn't generosity. It was extraction dressed as paperwork. My paternal grandmother and her two sisters co-owned a cabin. The oldest sister had passed, so her share went to her children, my dad's cousins. They weren't interested in selling. My dad and grandma rarely visited, but grandma always paid her share of repairs. Grandpa had handled all finances. When he died, my dad took over, especially since grandma was anxious about money and had never managed anything financial herself. She still hadn't paid dad his legal share from grandpa's estate. My Aunt Karen knew this. Karen was the youngest sister, the golden child. Charming, married well, used to getting her way. She spent every weekend at the cabin. For years, she'd wanted grandma's share. In 2006, grandma was recovering from cancer, stable, not dying, but physically weakened and emotionally fragile. Karen showed up unannounced and stayed overnight, which she'd never done before. A few days later, Dad called Grandma. She mentioned Karen had come by and they'd agreed on the cabin. Karen had brought papers to sign. Dad froze. It wasn't a deed, was it? Yes, it was. Grandma said Karen asked her to name a price. Not knowing the market value and never having dealt with property, she suggested $3,000. Karen took it. Dad was furious, not because he opposed the sale, he'd have supported it at fair market value. But this, ambushing a vulnerable elder, staying overnight to block outside input, presenting a ready-to-sign deed, that wasn't negotiation. That was predation. He called Karen immediately. She insisted, "Grandma set the price herself. I did nothing wrong." Consent extracted in isolation is just paperwork with coercion behind it. Dad hired a lawyer. So did Karen. All spring and summer, they fought. Grandma begged him to drop it. Family mattered more than money. But this wasn't just money. It was his legal inheritance. He refused. The trial lasted 2 hours. The judge ruled the sale null and void, a blatant violation of inheritance law. Karen walked in confident. She left with her head down. A week later, Grandma passed away. Karen didn't attend the funeral. Afterward, Dad sold his share, but made sure it went to his cousins, not Karen. He'd never let her benefit from the assets she tried to steal. She barely visits the cabin now. For the first time, she'd been told no and lost. Some people only believe in rules once they've been on the losing side. That spring, the cherry trees near the cabin blooms later than usual. This wasn't about greed alone. It was about consent laundering, manufacturing voluntary agreement from someone unequipped to consent, then using that paper trail to claim legitimacy. The overnight stay wasn't hospitality. It was operational security, ensuring no interference. The $3,000 wasn't a price. It was a performance of fairness, designed to satisfy surface scrutiny while gutting substance. And the phrase, "she set the price herself," that's how entitlement hides in plain sight, by outsourcing the script to the vulnerable. The real theft wasn't the cabin. It was the attempt to turn inheritance law into a formality you could outmaneuver with a signed sheet of paper. One reply dissected the maneuver with cold precision. You can't bypass heir rights by getting an uninformed signature on a deed. That's not a sale. It's a voidable transaction from inception. Another added, the law exists precisely because people like her assume emotional access equals legal authority. When someone uses your vulnerability as a shortcut to asset transfer, what's the real cost of that agreement? Is it the undervalued property, the legal fees, or the erosion of trust that makes every future offer feel like a trap?